Okay, we're back with Louis Pierro, founder of Pierro, Connor, and Strauss, talking the new tax plan. So if we chalk up predictions, corporate tax are 25%, estate tax sunsets, anything, we'll go to income taxes, but you were mentioning for large estates, they really do need to set up trusts now. And folks, call us at 888-988-JOSH if you want a free review for estate planning from a financial advisor. And if you practice, I'm sure we could rope Mr. Pierro into a free consult. Can we get a 2-for-1, Louis?
Absolutely. For your listeners and the listeners of the station, we will give a free consultation.
And watch, folks, on YouTube, The Financial Quarterback, Josh Jalinski. All you got to search for is Financial Quarterback. And you get a 2-for-1 special today when you call us at 888-988-JOSH and request your free review, your no obligation review. So Louis, what other estate planning tips? So slats with trust protectors, anything else that you would say, consider this?
It's a broad topic, but one of the fundamentals, and not everyone has 11.7 million, but if you have 5 million, you need to be concerned, maybe 3.5, depending upon what goes through. But everyone has an estate, whether you know it or not. And one of the things that we are very, very concerned about is having our clients have to get into protracted court proceedings. Now, as an attorney, I have a monopoly on the courthouse. I'm the only one that can walk into a courtroom or other licensed attorneys. So going through probate is something that law firms like because we make a lot of money. But avoiding probate is something that clients like because it keeps their family out of that court process. And we use another type of trust, a revocable living trust, for many of our clients so that they can have a smooth administration of their estate. It can be done with some tax planning for married couples, but everything in that trust is still yours. You control it 100%. But if you have those events, if you become incapacitated or upon your death, that trust is going to stand for you, and you're going to have successor trustees who simply step in and continue to manage. So I'm sure, Josh, you see in your practice people using revocable living trusts and putting their assets in and managing them and then having that immediate availability to a successor trustee without having to go through the court process. Sure,
yes. And folks, make sure you get a will, living will, power of attorney, healthcare directives, and a revocable living trust. That's a great tip also. So the slats, that was gold too. That's very good. What were you going to say, Louis?
We love acronyms. There are slats, grats, crats, all kinds of trusts. We use a lot of charitable planning for both income tax and estate tax planning. So if you have hospitals, colleges, charities that you want to benefit, those can be worked into your plan very effectively. We also do things called grantor retained annuity trusts, which shift wealth on to next generations, and just basic gifting, using your ability to gift. And a lot of people still think it's $10,000, but it's $15,000 per person per year. And you can also pay educational and healthcare expenses directly without having any effect on your gift and estate tax exemption. So taking advantage of the things that you can do year over year is a big step. Doing a trust, utilizing that lifetime exemption is a big step, avoiding probate. But I do want to touch on one asset because you can't do planning in a vacuum. And
let's talk about that one asset. But first, we're going to go to Carol, who is a question. So hold that thought. We'll have a little cliffhanger. Let's go to Carol. You're on with Josh Jalinski, the financial quarterback, and Louis Pierro. Go ahead, Carol.
Yes, hi, Louis, and thank you for taking my call. I'm wondering if there's any downside to gifting a rental property to my daughter. I would like to just get it out of my estate. I live in Connecticut, and she's living there now, and she's renting it. Is there any downside to that? I'm 73.
So there wouldn't be any gifting downside to that. You would have to file a gift tax return and claim the use of your exemption to shelter that gift. But there could be a capital gains tax downside. Because when you gift an asset, it carries your basis over. And I'm not sure what you paid for that property. You may have depreciated the property. But when you gift it, she's going to get your original cost basis. If she later sells it, she pays capital gains tax on that difference between the sale price and her basis. That's the capital gains tax.
Okay, and it would be even pretty much. I haven't gained much on the property. That's why I want you.
Then no harm there. No harm from a capital gains perspective. When we're going to talk a little bit about gifting, we just did, but when you gift to children, one way to gift to them is in trust. When you gift it to a child in a trust, their trust can be fully asset protected. So one of the other reasons we use trust is to protect assets from creditors, liabilities, bankruptcies, judgments. And so you may want to consider what we call a gifting trust. If you didn't want to make an outright gift, you wanted to have it protected for your daughter. And as a parent, I have 3 kids. They're all in their 20s. None are married yet. One is engaged. But if my children inherit from me and my wife and they get divorced, I don't want my assets that our family has accumulated to be lost in that divorce proceeding. If you put it into a properly designed trust for your daughter, it can be protected even from a divorce proceeding. So consider how you make the gift. If it's neutral from a tax perspective, and it sounds like it is, would it be better to just put it into her name or to create a trust for her where that asset can be protected? She could even be one of the trustees of that trust and manage the property for herself, and it's still protected from her creditors.
Okay, could I ask you another question quickly? If she decides, which she may move, and she said, I may rent that out for income. Mm-hmm. Would that trust, if it were in a trust, could she keep that in the trust and have it as a rental property?
Yeah, absolutely. Absolutely. We do it all the time. The other consideration, remember I said asset protection is important. If it becomes a rental property, one thing to consider is somebody slips, falls, goes down the staircase, breaks their neck, and sues you. You don't want to have all of your assets subject to that liability. So we put rental properties very often in entities like a limited liability company. So if she goes to a full rental, it could still be in the trust, but for liability protection from things that happen on the property, a limited liability company is absolutely your best bet.
Okay, thank you. It's in an LLC right now, so she would wait until she wouldn't have to have an LLC while she lives in it. Correct?
Well, if it's already in an LLC, that's what you're gifting. You're gifting the LLC.
Oh, I thought the title had to change because that's my LLC.
Do you have other things in the LLC?
Yes, other rentals. Yeah.
And yes, you would deed it out of the LLC to your daughter.
Okay, very good. Thank you so much for your help. I appreciate it.
You're very welcome.
Thank you, Carol. And we'll be back with the exciting conclusion to Lewis's cliffhanger when we return. This is Josh Jalinski, the financial quarterback. And folks, call us today for our retirement reality check. Are you prepared for retirement? Are you 10 years from retirement or already retired? Order your free retirement reality strategy session and you'll get a complimentary new guide fresh out for 2021 called Fresh Plays for 2021. It's our free guide to help you get back on track financially. Maybe you're concerned about asset protection. Maybe you're concerned about are you going to protect your family, tax saving strategies, and growth opportunities in this uncertain market. So give us a call now, 888-988-JOSH. And if you call us today, we'll get a 2-for-1. I pulled Lewis's arm. He will also give you an estate planning consult at no charge. We'll be be back after these messages. 888-988-JOSH.
The preceding program was sponsored by the Jalinski Advisory Group.
Any awards, rankings, or recognition by unaffiliated third parties or publications, including 5-Star Wealth Manager, Advisory of the Year finalist by Senior Market Advisor, and Top of the $1 Million Roundtable, are in no way indicative of the advisor's future performance or any individual client's investment success. No award, ranking, or recognition should be construed as a current or past endorsement of Josh Jalinski or Wealth Quarterback LLC. Information regarding specific awards, rankings, or recognitions is available on the Wealth Quarterback website at www.jalinski.org. All investment strategies have the potential for profit or loss. Investment strategies such as asset allocation, diversification, or rebalancing do not assure or guarantee better performance and cannot eliminate the risk of investment losses. There are no guarantees that a portfolio employing these or any other strategy will outperform a portfolio that does not engage in such strategies. This broadcast should not be construed by any client or prospective client as a solicitation to effect or attempt to effect transactions in securities or the rendering of personalized investment advice. Due to various factors, including changing market conditions, the information discussed in this broadcast may no longer be reflective of current positions or recommendations. While information presented is believed to be factual and up to date, Josh Jalinski and Wealth Quarterback do not guarantee its accuracy, and it should not be regarded as a complete analysis of the subjects discussed. The tax and estate planning information discussed is general in nature, is provided for informational purposes only, and should not be construed as legal or tax advice. Listeners should consult an attorney or tax professional regarding their specific legal or tax situation.
Advisory services offered through Wealth Quarterback LLC,